So the case challenging the ATF's ban on bump stocks has been set for Supreme Court conference. So let's talk about this. But real quick before we jump into this video, if you think Supreme Court needs to once again uphold our rights to keep and bear arms, go ahead and hit the like button and subscribe. I also want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense and liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. Also want to thank Blackout Coffee for supporting this channel. Blackout Coffee has amazing coffee, and they use a lot of their proceeds and they donate to 2A organizations. So great coffee, 2A supporters. If you guys are interested, you can use the links down in the details section. And if you use the code ARMSCHOLAR, you can get 10% off of your order. So like I said in the intro, a case challenging the ATF's interpretation of bump stocks as actual machine guns is seeking Supreme Court review and has been rescheduled for conference once again. The case we will be talking about is Aposhian v. Garland. Now, some quick background on how this whole issue arose and why this case is important, not just for bump stocks, but other ATF actions which violate our Second Amendment rights. For many years, the ATF had correctly concluded that the NFA and GCA's definition of the term machine gun does not involve devices like bump stocks. However, after the incident in Las Vegas, the ATF, after being ordered by then President Trump, decided to arbitrarily change the regulatory definition of machine gun so that bump stocks would be considered to actually be machine guns within themselves. The new rule took effect in March of 2019, and therefore under federal law, owners were required to either destroy the devices or to surrender them to the ATF. This change in definition made possessors of bump stocks subject to a punishment of 10 years in prison and or a fine of $250,000 if they failed to destroy or to surrender the devices to the ATF. The plaintiff in this case, Mr. Aposhian, purchased a slide-fire bump stock before the ATF's final rule was issued, like many other people did in America. After the ATF's change in interpretation, he filed this lawsuit against them, which is now seeking review from the Supreme Court. In response to this case and his petition up to the Supreme Court, the Biden administration filed their brief to the Supreme Court arguing that the ATF has appropriately interpreted the term machine gun to encompass devices like bump stocks. The three main arguments the Biden administration makes in their brief to the Supreme Court is that the petitioner has failed to show a likelihood of success, that there is no division in authority warranting Supreme Court review on this issue, and that the question of Chevron deference does not need review. After the Biden administration filed their response, the petitioner or the plaintiff here filed his reply. In his reply, he argued that the Supreme Court should review this case to determine if Chevron can be waived, if Chevron applies to criminal statutes, and they also argued that this case is well suited to address issues of exceptional importance, i.e. ATF overreach and violations of Second Amendment rights. If you're not aware of what Chevron deference refers to and you're hearing me talk about Chevron deference is a term coined after a landmark case referring to the doctrine of judicial deference given to administrative actions. Generally, for an agency to be given Chevron deference, the agency's interpretation of an ambiguous statute must be rational or reasonable. So when a statute has ambiguous terms, the agency responsible for enforcing that statute may be able to determine what that term was intended to mean as long as their interpretation is rational or reasonable. In contrast to Chevron deference, there is this thing called the rule of lenity. The rule of lenity indicates that when dealing with criminal statutory interpretation, a court is required to apply any unclear or ambiguous law or term in a way that is most favorable to the people, not the enforcement agency. The interpretation of the definition of a machine gun does involve criminal penalties, and therefore the argument is, in this case, that the rule of lenity would direct this court or any court to interpret it in a way that is most favorable to the people, not to the ATF. Now, Aposhian was originally set to be distributed to the Supreme Court for conference back in last December. At the conference, the Supreme Court would actually consider whether or not they wanted to address this issue of ATF overreach. However, we were waiting to see what they would do with that conference. We likely, usually when they have a conference, you'll hear the next week maybe what they decided to do. But when we were waiting, the Sixth Circuit actually issued a ruling in another bump stock case called the GOA v. Garland case. These two cases are similar in nature but arose out of different plaintiffs and out of different circuit courts. The Sixth Circuit, in reviewing the GOA case en banc, in reviewing that case, they were unable to reach a majority opinion and instead issued a rare 8-8 deadlocked ruling. This deadlock ruling in the Sixth Circuit resulted in no precedential appeal court decision, and by default, the lower court's ruling in favor of the ATF was affirmed. Now, after the Sixth Circuit's 8-8 deadlocked opinion, the Aposhian case, which was set for conference, was removed from that conference and that schedule. In response to the Sixth Circuit ruling, the plaintiffs in that case, Mr. Aposhian, filed a supplemental brief to the Supreme Court, pointing to the GOA case and the inability of even 16 judges to reach a decision. The Aposhian plaintiffs are using the Sixth Circuit decision to bolster why the Supreme Court actually needs to resolve this issue and hear this case. One of the big things that the Biden administration argued heavily in their briefs on why the Supreme Court does not need to address this issue was that they claim there is no conflict between lower courts on this issue. However, like we saw in the GOA case, not even a single panel of 16 judges can decide on what they should do. After the Supreme Court pulled the Aposhian case the first time, it was then rescheduled multiple times, and most recently it was pulled, but then it was kind of up in the air, and we were wondering if it would be set for another conference or if the Supreme Court would maybe put it on hold like they have with some other cases pending their decision and their ruling in the New York State Rifle and Pistol Association v. Bruin case. However, we recently got an update from the Supreme Court's docket that the Aposhian case will be set for conference on February 18th of 2022, so next Friday. So they will be taking up this case on conference, and if anything else happens, I will let you guys know. But with a case like Aposhian, it does not just impact the ATF's attack on bump stocks. It could also impact other recent actions that the ATF has taken. Recently, the ATF has been aggressive in targeting various trigger groups like the rare breed FRT triggers, the Big Daddy Unlimited WOT triggers, and saying that those are also machine guns within themselves. The ATF will also be dropping their new proposed rules on frames and receivers and pistol braces this year in June and August. So again, the ATF has been aggressive against the triggers, frames and receivers, pistol braces, and this Aposhian case would go a long way to correcting the ATF's continued overreach and attacks on these various rights and our access to various arms that they're now arbitrarily defining however they want. So I really hope the Supreme Court takes up this case, takes up this issue, because again, this is something that would not just impact bump stocks. I know a lot of people don't care about bump stocks, and that's how this kind of got out of control, because a lot of people said, well, I don't care about bump stocks. I don't need bump stocks. The ATF can do whatever they want. But we saw that they have not stopped at bump stocks. They have moved on to other things as well, like pistol braces, like frames and receivers, which does actually impact a lot of people. So this is a case that can go a long way to stopping those attacks also. So if you guys have any questions, go ahead and comment down below, and I'll try to answer the best of my ability. Also, if you like this video and support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I cannot thank you guys enough for everybody who's liked, commented, subscribed, who's hit the notification bell. You guys are directly impacting this video, impacting this channel, and helping me to reach and educate more people than I could have ever thought. So again, thank you guys for all of your support. If you don't have a comment in mind, just comment down below, just comment to fuel the algorithm, and that really does help the channel. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget, this stays with Built Bar Arms Scholars, and this nation will maintain Bar Arms Scholars.